to jump in. Again, my name is Julie Murphy. I'm the director of the Colorado Oil and Gas Conservation Commission. It seems as though our participant number has started to stabilize. This meeting is being recorded, so anybody who misses it or wants to go back to listen to it absolutely can. I'm going to work on sharing a screen. Excellent. Hopefully folks can see it. If something happens and my internet gets dodgy and isn't supporting my audio feed, please let me know as soon as you can. It's very awkward talking to a room when nobody can actually hear you. As I said, we're here to talk about the financial assurances rulemaking, and this is our stakeholder meeting. Yesterday, staff provided notice to the Secretary of State of draft financial assurance rules, and I believe there's also been a case management order filed within the system setting out deadlines for the process. With that, I want to touch on kind of two key pieces. One is, what does participation in the rulemaking look like? And then jump into some of the substance of staff's proposed rules, and then there will be time for questions. I only have about 16 slides, so this may go fairly quickly, and there's plenty of time for questions, whether it's today, whether it's in the future. What I will say, to me, financial assurance is one of the most complicated and interesting topics that I've worked on professionally. I think it takes a lot of time to digest different frameworks and approaches. And so I would encourage folks, as you are thinking about this topic and reviewing staff's proposed rules, my first ask is, it's really easy to want to jump to the end or to get to the punchline or get to the bottom line and look at the dollar amounts. But I think the most important component of staff's proposed rules is the framework that is developed. And so what I would ask everybody who really wants to participate and engage is, think first about the framework that we've put together and think about if that framework makes sense for Colorado. And then once we get past those big picture framework conversations, then we can have a very thoughtful policy debate about the dollar amounts or the time periods or the different quantitative components of those rules. So I guess that's a little preview of what you're going to hear in just a little bit. But again, first I want to start with public participation opportunities in the rulemaking. Here I've tried to put together some of the key dates. Party status is the mechanism by which parties can engage kind of at the highest degree with each other in the rulemaking itself and with the commissioners. The deadline to request party status is June 23rd of this month. The other alternative for participating in the rulemaking is to submit public comment. That can be submitted either in written format or in oral feedback to the commissioners themselves during the rulemaking hearing. September 10th is a deadline for written comments, and that deadline allows our commissioners the opportunity to review and reflect on those written comments in advance of the hearing starting itself. And then September 16th is a deadline to sign up, and that allows staff to manage the hearing process and make sure we've allocated enough time for all of our public commenters. So those are the two big picture pieces. Again, the key dates: June 23rd to request party status, September 10th for written public comments, and September 16th to sign up for oral comments. This is just kind of a chart of the different deadlines for party participation. Pre-hearing statements due July 16th, responses to pre-hearing statements August 20th, pre-filed testimony and associated exhibits September 10th. Again, the written 512 statements, September 10th again, and then September 16th, the deadline to sign up for public comment. The hearing dates that we have marked out are September 21 and 22, 29 and 30, October 1st, October 5th through 8th, 11th through 13th, 21 through 22, and 25 through 28. That looks like a huge number of dates, and that's because we're trying to be very cognizant of how many participants are engaging and making sure we allocate enough time for our commissioners to move through this incredibly important topic. I think that the current plan would be for staff to open on September 21st and 22nd with a presentation of the most current version of staff's draft rules at that point and kind of lay the foundation, and then let parties come back and public commenters come in to have a dialogue with commissioners about that draft and about, you know, ongoing concerns or issues. And then at some point, the commissioners can give feedback to staff to make revisions and then come back for kind of a final closing presentation from parties, public commenters, and for the commissioners. So more on that to come. And also, again, the case management order, which lays out more information about these deadlines, is available. For people who have questions about this process and how things are rolling and who or what and where to connect, if you have questions about the e-filing system, please contact Angelica or Margaret. If you have questions about procedural matters, how are deadlines rolling, maybe you miss a deadline and you need to understand what that means, please contact the hearing officer, who is Jeff Fugate, for this matter. All of those emails are on the screen if you want to take note of them. And again, both this presentation and a recording of this presentation will be available should you need to refer to it later. With that overview of the process, I'd like to jump into the substance of staff's rules. And again, I'll reiterate where I started, which is to say that first, as you're reading through staff's rules, think about the overarching framework and what it means and how the components fit together for the commission to oversee financial assurance for oil and gas operations in Colorado. You know, and then once you kind of think about that, think about what the numbers are, what the timeframes are, how they all work together. I'm going to try to do that as well. So I think one of the most important changes in staff's rules is that all operators will be required to provide the commissioners a financial assurance plan that sets forth in detail what facilities and what financial assurance approaches that operator thinks is appropriate. Staff will review that, make a recommendation, and the commission ultimately has oversight of an operator's financial assurance plan. And that's kind of round one. We would expect, as drafted today, those financial assurance plans to be submitted by July 1, 2022. And then kind of I'll preview what we'll cover on a future slide, but there would be then an annual review by staff or the commission, depending on the circumstances of that financial assurance plan. One of the key components, again, of financial assurance is financial assurance for wells in particular, or oil and gas facilities associated with wells. And what staff's draft proposes is a tiered approach to financial assurance with the kind of three generic tiers. And there are some important detail missing from the slide that you'll have to read the rules to see, but for me, one of the big picture pieces as we've gone through the financial assurance information gathering process is looking at where are places where there is some risk or concern. And I think that some of the information presented throughout that process really related to to inactive wells in particular, or low producing wells. And so the tiers that staff has proposed are really focused on, one, are you keeping wells productive, or are you actively, as not you being the operator, or are you actively plugging and retiring your assets as it becomes appropriate? So again, the tiers right now are focused on looking at, does an operator have a small or large percentage of low producing wells, or is the operator actively plugging their wells, which eliminates the future risk of orphaning if those wells are plugged properly. So that's kind of the framework. Again, there's tier one, which would be the less expensive blanket bonding approach. Tier two would have higher blanket bonding, and then operators that don't achieve tier one or tier two can prepare a sinking fund and pay into that fund over time to get to bonding up to the full amount. So that's the overarching framework. Again, the commission operators submit a financial assurance plan to the commission, staff reviews it, the commission ultimately evaluates it, and operators can be in different tiers based on the information that we have about risk in terms, and then pay into it accordingly. There are a couple of really important definitions in my mind. And again, this is framed very much by the last few months in the work through the informational docket, talking about the definition of inactive wells. And currently COGCC does have a definition of an inactive well. Right now, that's, there's no production sold for 12 months. Because there are some challenges with administering that definition, we thought it was more straightforward to look at actual production from the well as reported by the operator on the Form 7. And so an inactive well, staff would propose to define as a well that produces less than 1 barrel oil equivalent BOE per day over a trailing 12-month average. So that's a very, very low production number. For context, stripper wells, it's a 15 BOE per day metric. And I think that inactive is an important component, and I think that the SOGR review really touched on what to do with idle and inactive wells. But in my estimation, once you get to kind of that idle or inactive status, it may be too late. And so I think I have suggested in these rules that we should also define something called low producing wells that lets the commissioners look into an operator's operations a little bit earlier. And so we've proposed a definition that a well that produces less than 5 BOE per day over a trailing 12-month average would be considered low producing and would be an indicia that we should take another look in some circumstances. I think that these numbers, like many of the other numbers, are really going to be at the heart of the policy discussion that occurs over the next couple of months. And I look forward to folks' feedback on if those are the right numbers and what they mean. With the definition of inactive, we also have imposed a couple of regulatory requirements. We looked to the Texas definition in particular around this. And the idea is there would be 4 options for a well becoming inactive: plug the well, return the well to production, bond up by submitting a single well financial assurance, or put the well on a plugging list. And this 4th option, the plugging list, is to me a fairly new concept. I don't think that there's a corollary in other states where I've reviewed financial assurance requirements, but the idea is that there are some subset of wells that an operator that have become inactive for any number of reasons that an operator does not intend to return to production. And so they kind of go on their own list, the plugging list, and achieve an out of service status. I think that this is an area where we should have a lot of robust discussion about what are the operational requirements for being out of service. And you won't see much of that discussion in the rule series because I think that's a really appropriate place to get a lot of feedback. So I'm looking forward to that discussion as well. And then the other key component in my mind around this is that after 3 years, whether a well is inactive or on the plugging list, it does need to be fully bonded. And that's, to me, an important component, again, to make sure that we are moving, wells either into production or they are being plugged. And again, how that time frame fits in, I think, will be a good part of the ongoing discussion. The other place where we've received some feedback around risk and concern is around transfers. And I think a lot of this conversation came up through the bankruptcy space. And to be clear, the commission can't change bankruptcy options, right? But what we can do is look more closely at transfers and transfers of wells. And so currently, staff has proposed that all transferred inactive wells require a single well full cost financial assurance. I think that this is a place, again, where we can have pretty robust discussion about whether that's the right approach, whether there are other factors we should be considering. And then there's also a component that the commission will take a look at transactions that involve more than 30% of low producing wells. Is 30% the right number? Let's talk about it. But the fundamental point is to make sure that we're taking a look at how transfers are occurring, and are they transferring the entire acreage, or are we just kind of carving off some of the low producing wells, and what does that mean and how should we think about it? So those are some of the principles or the thoughts that have gone into the idea around looking more closely at transfers of assets. That builds in very nicely to the Rule 218 that we adopted last fall around transfers as well. other component of the rulemaking, and again, as I've talked about these ideas over the last couple of months, there are concepts around financial assurance, idle wells, and then the Orphan Well Fund and the Orphan Well, what that means. So staff's draft proposes a new and entirely separate orphan well fee that is a per well fee paid by operators annually. The idea is that it becomes the sole source of funding for the orphan well program. And, you know, at some point, and today is not the day to make that decision, an adjustment to COGCC's mill levy likely will be appropriate because right now the mill levy is funding the orphan well work for the most part. What staff has proposed is kind of a phased approach. So assuming the rules are adopted as proposed, which is not a safe assumption, the per well fee would be $100 per well in 2022, given that there are approximately 50,000 wells in Colorado that would generate about $5 million. And then in the subsequent year, in 2023, that fee would bump up to $200 per well, which would provide an approximate revenue of $10 million. And so we're looking to double the size of the program. And I also acknowledge that as part of this rulemaking, if there is a new fee or a new revenue stream that changes COGCC spending authority, we will need to go to the legislature. We likely could seek an enterprise or other solution for this revenue stream, and that will be something that we will have to be thoughtful about as we close the loop on adopting these rules later this fall. To be clear, the fee will only be spent to fund the Orphan Well program. It won't go towards COGCC's operations at all. Again, we rely on severance tax and mill levy to fund COGCC's operations. I think that this proposal creates a lot of transparency around who and how is industry paying for plugging and reclaiming orphan wells. I think I've just been told that I froze and now crashed. Can anybody hear me? Apologies for that, folks. We had a little glitch on my end, and so I just left and jumped back into the meeting. Thanks for your patience. Hopefully Ms. Larson can enable me to share my screen again, and I'll jump back in to the discussion. Maybe Mr. Miner, can you share your screen and run the slides? Okay, I think we should be good to go. Oops. Whoops. Okay, so I think I largely wrapped up the conversation about the orphan well fee. If if anybody missed some of that discussion, please ask me a question and I'll jump back into it, but I'll keep moving forward. One of the other pieces that we are wrapping up as part of this rulemaking is readdressing Rule 211 and the used or useful concepts, and then establishing a process by which that determination can be made. Again, this is kind of work that, as part of mission change, we deferred to part of the financial assurance conversation, seeing that it fit better in here when we talk about things like used and useful, inactive, and active. One of the other components that I think has been part of the dialogue this spring through the informational docket is around insurance and remediation costs. And so staff has proposed a requirement to have a per occurrence environmental liability insurance policy, and also to codify what practice has been around staff reviewing and requesting additional financial assurance for spiller releases that have a large scale impact, to ensure that the state is protected in those instances. Next are kind of some of the more procedural components, but making clear what are, preferred types of financial assurance, and eliminating something called bond writers. There's a very good discussion and explanation of that in the statement of basis and purpose, which I would recommend everybody take a look at. It is lengthy, but it is well written and helps articulate and provide context for how many of these provisions fit together. And then also in Rule 703, we're proposing some changes to the type of bonding and the amount of bonding for particular facilities that would not be covered by a blanket bond or the well bond, discussed and proposed in Rule 702. And then, as with so many of the rulemakings we've undertaken in the last couple of years, there are overarching themes to the rulemaking: cleanup, clarifying, and making sure our rules are more readable, not in the passive voice, etc. A number of these changes are reflected in proposed Rule 704 and 706. We are proposing a new Rule 707 that talks about, again, what does the review of financial assurance look like after July 1, 2022, when the first financial assurance plans would come in for an operator. And it allows, some staff level review, some commission level review, depending on a particular operator's characteristics, adjustments for inflation, and the opportunity for the commissioner or the director to review financial assurance plans at any point in time, based on relevant risk factors. So again, we're trying to build a larger framework around how we look at this, how we talk about this, and how the commission formally takes action on financial assurance in a timely way. So again, Rule 707 is a lot about process and about how things will work and will be reviewed going forward. There are a couple of other changes and other rule provisions. Again, cross-references, typos, and making substantive changes that conform to other rules. I think that's probably the lion's share of the presentation. Again, I think there is lots in here that helps advance the discussion that we've started through the informational docket, or maybe perhaps started back in 2017 when we really started digging into the question of financial assurance in the Orphan Well program. Again, I would ask that everybody take a look at the framework, take a look at the SBP, think about the big picture functioning of these provisions and how they work together, and then think about the actual numbers within them and whether they're the right balance, whether they're not, and how we can move forward and again have that really robust policy discussion that I'm looking forward to later this year. I think we've had a lot of attention and a lot of interest in this topic. I think it's incredibly important and really look forward to watching this unfold. With that, I am happy to take questions if folks have questions now. I know that for me, at least, financial assurance is one of those topics that, listening to it the first time through, it takes me a few days to digest it. So if questions come up afterwards, please don't hesitate to reach out. This is one of my, this is a topic that's very important to me and that I spent a lot of time thinking about, and I look forward to engaging with everybody on. I see that we're up to 100 participants. I suspect somebody might have a question, so I'm going to stop the share for now and see if folks have questions. Ms. Larson, I don't know if if you have any suggestions for managing this. And I
Director
think,
Murphy,
yep,
this is Chair Robbins. Can you hear me?
yep.
Yeah, so I just wanted to first thank you for the release and for the information this morning. I've seen a number of people on the chat with concerns that tonight's hearing is the public comment is already closed. Tonight is not the night in which we are taking financial assurances public comment. The release was just released. And so everyone needs to spend some time with it. So don't want folks feeling anxious about the fact that they've not been able to sign up to speak on financial assurances at the evening meeting this evening at 6. So just wanted to make that clarifying point. And now I will let Ms. Larson help continue run the meeting.
Thanks, Chair. And again, the party status deadline to participate as a party in financial assurance is the 23rd. And then the deadlines for signing up to give public comment, whether it's oral or written, as part of the financial assurance rulemaking procedure or proceeding are in September. And I think that, again, that it's important that we hear from Coloradans and about that topic in one of those two formats.
And thank you, Director Murphy. And I would just recommend for participants, if you would like to ask a question, probably the most efficient way is for you to go ahead and raise your hand, and we will note then that you wish to ask a question, and we'll unmute you.
Hi, I would like to ask, why are the fees per well so low for like 200? I mean, I've seen permits for other things a lot more than 200, and especially for something so detrimental to our environment and our public health. I think it's very low of a fee. Is there any chance of raising that fee per well?
Thanks for the question. And to clarify, the fee per well is strictly to fund the Orphan well program itself. We haven't undertaken a permitting fee rulemaking at this point in time. That is something that 181 does contemplate, or Senate Bill 19-181 does contemplate. And so again, when I was looking at setting that fee, it was really to guide what we think the revenue into the Orphan well program could be and what we think we can manage to spend. And so that's one component of the financial assurance rulemaking, but it's not the entirety of it. So I hope that helps. Thank you for the question, Ms. Oliver. One of the questions that's come in via chat is this the only stakeholder meeting? This is the only formal stakeholder meeting that has been scheduled currently. If there is a need to have a second or a follow-up one, we're happy to do it. Please let me know if you think it would be helpful. And I'm scrolling through, and Ms. Larson, correct me if I'm wrong, but I don't see a ton of hands raised, or I don't really see any. And if that's the case, we can wrap up today, recognizing that this is the start of an important conversation and not the end of it, but one to kind of kick it off.
And Director Murphy, we do have Mr. J.D. Roybal. We will bring him in one moment.
You know, you'd mentioned that you can't, I can't remember the correct verbiage, but you'd mentioned that you cannot control the rules of the bankruptcy. However, is there a mechanism that you can actually control what happens as a result of the bankruptcy? In other words, prepare for that eventual bankruptcy. Because if you notice, there's actually a history of these corporations just instinctively just claiming bankruptcy as a means to escape all responsibility. And then they simply reorganize as a different organization. Now, utilizing the excuse that you can't change the rules, it seems like there should be a mechanism in place that you may have a way that you can actually advance protecting the people. against systems like that. Can you delve in a little bit more within that?
So I think that's an important question. And I think that the pieces that, we want to look at as part of this rulemaking is making sure that we're looking at least annually at operators and how things are going, how production is coming in, and understanding what it is. And that's why this annual process is really important. When I think about the framework of how to make these decisions and how to rewrite the rules, is having that annual kind of check-in and review. And the other component for me is making sure that we're looking hard at transfers, because a number of assets that enter bankruptcy also come out of bankruptcy, transferred to somebody else. And if we collectively look at how transfers are occurring and apply that, that would be equally applicable. So I think that those two pieces help address your concerns. But I encourage you to take a look at both the SBP and the rules themselves, and look forward to engaging on this process. And I guess the one other piece that I wanted to jump in on is we did add definitions with the recommendation of our bankruptcy counsel around cash bonds and surety bonds to make sure that we've done all that we can to protect the state and in financial assurance that we hold. So I see Mr. Dean raised a hand. I can't unmute you though, so I'm gonna have to wait for Miss Larson.
Yes, thank you. I'm kind of on that same avenue, and admittedly, I haven't gotten through the entire draft rules yet. Do you envision the commission through the hearing process, in the example that 30% or whatever that number ends up being during the transfer of inactive wells, do you envision the commission will somehow deny the transfer of permits or active assets if after that hearing the commission finds that an operator or selling operator is planning to transfer a number of assets to the orphan well program, or tends to abandon them in some other way? Kind of like a take it all or leave it all type of situation. Either you transfer everything to another operator or you transfer nothing type of situation. Is that how you envision that hearing process to go? Or
I mean, perhaps, but I think the bigger picture piece that I want to make sure that we're looking at is transfers generally. There are lots of transfers in the oil and gas industry that end up being beneficial in terms of consolidating acreage, consolidating planning. There's lots of really beneficial components of transfers. And so I think what I envision is the opportunity to take a look and understand the selling operator's position, the buying operator's position, and understand what that could mean or should mean in terms of operating those wells moving forward. I hope that helps a little bit. I know I'm not being incredibly specific, and part of that's because it's a pretty precise hypothetical that we'll have to wrestle with. And again, I think if we build the right process, the commissioners can make those evaluations.
Hi there. This is Christy Douglas, and I just wanted to say that JD had a really good point. We've experienced that same scenario in Commerce City with PetroShares now becoming another company. And one of our council people actually works for that company. So to me, we have to be careful of the shell game that's played by this industry, because they just move things around and somehow they always come out on top. And we have to be aware of that. So I don't really have a question, but I'm saying that we have to beware, and we have to have rules set in place that aren't going to allow that kind of activity in the industry to continue to happen. So I just want you to know the public we're aware and we're watching. And so you're going to have to really understand that. And to make these, if the rules seem severe and harsh, so be it. Because we just can't afford to let them continue to operate as they have in the past. And that's to run amok and do whatever they want because they know how to work the system. So that's all I have. Thank you.
Thanks, Ms. Douglas and Mr. Roybal. You know, I would really encourage you to take a look at the SBP and the rules that are out there and see if they do provide that kind of transparency and accountability that you have concerns around. And I'd be happy to sit down with one or both of you and talk about my perspective and what shaped it and how I think they'll work, you know, as we get into the rulemaking process. And again, today is just an introduction of staff's rules. Really getting into the substance and the meat of what a policy position should be is really best served as part of the rulemaking process. So I hope both of you plan to follow that and engage in some capacity.
I appreciate the opportunity, Julie, so I will take you up on that. But I do want you to know that I want it to be a dialogue. I just don't want it to be where you're going to tell us your perspective and not listen to our perspective. Because we know we know that we can do this, and we're, as the public, we're tired of hearing you say there's nothing you can do about it. You're in charge. So when we do sit down and talk, I want it to be a dialogue. I want you to listen to us as well. So thank you for the opportunity, though. I really do appreciate you offering that.
I look forward to listening.
Thank you.
Yep. One of the questions that came in via chat is low production is based on trailing 12 months. Do you expect there to be a mechanism to account for well-repaired downtime or an economic upset? And I think that that's a question that folks should fold into the conversation as we move forward. You know, those are the types of concerns or issues or questions that we would look forward to seeing in, again, public comment or party statements to try to work through. I think I see two more hands raised, Mr. Moore and Ms. Rose, and maybe we'll take those. And then again, please reach out to me to discuss staff's position and your position and what you think it means and where you think we should go. And also, please do engage in the actual rulemaking process, whether it's via public comment, written or oral, or as parties. Ms. Larson, can you unmute Mr. Moore and then Ms. Rose?
Thank you, Director Murphy. This is Jeffrey Moore. I'm the manager of the Oil and Gas Division with the City of Aurora. I just want to say thank you to you and the staff for a great start to these rules. I'm really excited to read through the details behind everything, but I think you've really begun to address some important concepts here. Certainly there's room for discussion on all of these topics, but I think this is a great start, and I really applaud you for taking this on and giving us a great place to begin the discussion.
Thank you, Mr. Moore. Ms. Rose?
Thank you, Ms. Murphy. I just wanted to circle back around to the comment in the chat and an earlier slide about low producing wells and understand a little better that there are significant tax consequences to low producing wells. And are we setting up two tiers, one being less than 1 BOE and one being less than 5 BOE? Is that the plan for how to handle what are, you know, colloquially known as stripper wells?
Ms. Rose, I think I understand the question. I mean, functionally, the definition of a stripper well is set out by the Department of Revenue and statute. So it's not something we have control over, but what I did want to do is try to take a lot of the stakeholder feedback we received this spring and think about what lower producing wells should mean and when we should start to take a look. I think whether, you know, staff's proposed numbers are the right ones will be an area of rich policy discussion over the coming months. Mr. Roybal, I believe you're unmuted.
It almost seemed like we're only allowed one question. Are we allowed more than one question? I'd like to have that clarified for everybody within the group.
There are more than one question allowed. I hadn't seen as many hands raised to request them. So I thought we
Mr.
were.
Roybal, this is Jeff Robbins, Chair. This is just the beginning of an extensive process. Today was an opportunity for staff to give perspective on the staff draft. They've done that. We will be obviously taking lots of questions and lots of public comment over the course of the next 5 to 6 months. But I appreciate Director Murphy's taking some initial questions this morning, but this is not the opportunity for all questions. And you know what I would hope that you will do is with everybody is let's all spend time reviewing the draft rules and getting up to speed on them and getting prepared for next steps.
Can I respond to that?
No. Thank you. Thank you again, Director Murphy, for a great introduction this morning. We look forward to all the next steps. As some people have asked, if you'd like to take a look at the staff's presentation, it will be online and you can go and track all those dates, et cetera, for opportunities for full involvement in our process. And we look forward to everyone being involved.
Excellent. Great. Thank you, Chair. With that, Ms. Larson, I'll leave it to you and Angelica to get everything posted and look forward to next steps. Again, please don't hesitate to reach out to me if you want to talk offline about any of these draft rules or the process moving forward. I appreciate everybody's time.